Hello everyone, I am Advocate Snigdha Behera. So today we will be discussing set C of OJS question 2023. So let's start. We'll start from the first question. The first question says, the important case of the Supreme Court N. Balakrishnan versus N. Krishnamurthy is related to option number A, length of delay is no matter, acceptability of the explanation is the only criterion. Option number B, the condemnation of delay is a matter of discretion of the court. Or option number C, widen the scope and ambit of law of limitation. Or option number D, all of the above. So this is a case law, so you can find it either in the Google or from any other case law book. So the correct answer would be all of the above. And it is related to section 5 of Indian Limitation Act, that is doctrine of sufficient cause or doctrine of condemnation of delay. Okay, let's now go to question number 2. It states that a suit for possession of immovable property based on title can be brought within 12 years from option number A, the date of dispossession, option number B, the date of demand of possession, option number C, the date on which the defendant refuses to deliver possession, or option number D, the date on which possession of defendant becomes adverse. So this is a direct question. So if you read Article 65 of Indian Limitation Act, so the correct answer would be option number D. Generally, students are confused between option number A and D, but since this is a direct question, so the correct option would be option number D. Let's go to question number 3. If the defendant is abroad during the period of limitation, the options are A, such period is excluded from the period of limitation, option number B, such period is included in the period of limitation, or option number C, such period is excluded from the period of limitation only if the period to stay abroad is more than 30 days, or D, none of this. So this is also a direct question. So if you refer to section 15 clause 5 of Indian Limitation Act, it is very clear that when the defendant is abroad during the period of limitation, that is when he is absent, the such period is excluded from the period of limitation. Let's move to question number 4. Which of the following amount to presenting civil proceedings with due diligence and in good faith within the meaning of section 14 of the Limitation Act? We all know that section 14 deals with bona fide exclusion of time for proceedings bona fide in court without jurisdiction. So here we need to find out of these 4 options which are the options which fall within the meaning of due diligence and in good faith. Let's see. Option number A is failure to pay the requisite court fee found deficient. This clearly indicates that it is a failure from the plaintiff's end. So option A doesn't fall within the meaning of due diligence. Let's see option number B, error of judgment in valuing a suit. So error of judgment, this is also a fault from the plaintiff side, because for finding out the valuation of a suit, we have a suit valuation act. So here we can, it is very clear that there is an error from the plaintiff's end. So here both the options A and B doesn't fall within the meaning of due diligence and in good faith. But the question is, which of the following amount to presenting civil proceedings with due diligence and in good faith? So we are very clear that neither option A nor option B falls within the definition of section 14, due diligence and in good faith. So the correct answer would be option number D. Let's move to question number 7 now. Which of the following sections of the code, that is CPC here, expressly prohibits a suit under certain circumstances? As far as my knowledge is there, section 9 is the only section which expressly bars the institution of suit. But here section 9 is not there, so we need to find out of this 4 which is the correct one. Section 10 deals with res sub judice, that is stay of suit. Option number B, section 11 deals with res judicata, that is bar of suit. Section 10 doesn't exactly prohibits, puts a bar on the suit, but it puts a bar on the trial of a suit. And section 47 deals with questions to be determined by an executing court. Here there is a bar on a separate suit. So the correct answer would be all of the above. Let's move to question number 8. Which order of the Civil Procedure Code provides for a representative suit? This is also a direct question. We can find it in Order 1, Rule 8. Let's move to question number 9. Order 39, Rule 2 of the CPC deals with. So here the options are attachment before judgment, temporary injunction, execution of decree or appointment of receiver. So here attachment before judgment is dealt under Order 38, temporary injunction is dealt under Order 39, execution of decree is dealt under Order 21, execution of order and decree, appointment of receiver under order 40. So here the correct answer would be option number B. Let's move to question number 10. Under which section or order of the CPC a provision is made to provide free legal services to indigent persons? So here, if you have read all the orders, you can clearly identify that suit by indigent persons is dealt with under order 33. So these two options are eliminated. Now we need to find out of C and D which is the correct one. So here, since it is a direct question, so the correct answer is Order 33, Rule 18, deals with free legal services to indigent persons. This is under CPC. However, under CRPC, Section 304, we can find Section 304 deals with such provision. Let's move to question number 11. Compounding of offence under the provisions of the code in criminal case when charge was framed results in acquittal of accused, discharge of accused, release only, case filed only. So this is also a direct question. It is dealt under section compounding of offences. We can find under section 320 of CRPC. So if so the correct answer would be acquittal of accused, which is dealt with under section 320 and 8 of CRPC. Let's move to question number 12. A charge sheet is filed under section 202 of the IPC. That is punishment for murder against 5 accused A, B, C, D and E. A and B are absconding. So here charge sheet is filed under section A, B, C, D, E and D and E are accused of murder. A and B are absconding. A and B are absconding. And C is exempted from personal appearance. C is exempted from personal appearance for the order of the court. D and E are present in the court. D and E are present in the court. Okay. So the case can be committed to the court against A and B, B and F, D and E, and all the accused. Here the correct answer would be all the accused, because even if they are absconding, they are part of the process. They are part of the trial. And here C himself is exempted from personal appearance by the order of the court. He need not be there, but he might be called whenever required. D and E are, since D and E are present in the court, so the case against all of them will be committed to the Sessions Court. Okay, let's move to the next slide. Okay, now let's start with question number 30. The court can record demeanor of a witness under which section of CRPC? Section 280, Section 279, Section 278 or Section 281. So this is also a direct question, section-based question. The correct option, the answer is option number A. Let's move to question number 40. It is obligatory upon the court to grant bail to the person convicted pending presentation of an appeal under 389 subsection 1, 389 subsection 2, 389 3 or 389 4. Here the correct answer is option number C, that is section 389 subsection 3. Recently Rahul Gandhi also obtained bail under this section. Let's move to question number 15. Which of the following has been specifically excluded from the definition of complaint under section 2D of the CRPC? A. Protest petition, B. Joint complaint, C. Police report or D. None of this. This is also a direct section-based question. So the correct answer is option number C. Police report. Let's move to question number 16. Which of the following gifts is valid? A gives rupees 5,000 to B on condition that he shall murder C. Here the object murder is opposed to public policy and immoral. So this option is eliminated. And option number B, A makes a gift of his field to B with a proviso that if B becomes insolvent, B's interest in the field shall cease. This is also, let's keep in abeyance. Option number C, A makes a gift of his field to B with a condition that if B does not within a year set fire to C's house, his interest shall cease. This is also opposed to public policy. So this contract cannot happen. This gift is invalid. Let's move to option number D. A makes a gift of a house to B on the condition that the gift will be forfeited if B does not reside in it. So this seems like to be a genuine condition. So this gift is valid and all the rest options are eliminated. Let's move to question number 17. Under the provisions of Hindu Succession Act 1956, any property inherited by a female Hindu from a father or mother shall devolve in absence of any son or daughter of the deceased, including the children of any predeceased son or daughter, A, upon the heirs referred to in section 15(1) of the Act, B. Upon the heirs of deceased female Hindu's father. C. Upon the heirs of deceased female Hindu's husband, or none of the above. So here this is also a section based question. 15 we all know that 15 deals with general rule of succession in case of a female Hindu. Here option A is eliminated, option B is the correct answer, and C and D are also eliminated. Let's move to another slide. Okay. Question number 18. Proceedings to be in camera and may not be printed or published is provided in section of the Hindu Marriage Act 1955. This is also a direct question. The correct answer is section number 22 of HMA. And let's move to question number 19. Escheat under Hindu Succession Act means escheat is dealt under section 29 of Hindu Succession Act. The options are: individual dies intestate and doesn't leave behind an heir. B. Individual dies intestate and doesn't leave behind an heir who is qualified to succeed to the property. Option number C. Individual dies intestate and doesn't leave behind an heir who is qualified to succeed to the property. The property devolves on the government. Option number D. Individual dies intestate and doesn't leave behind an heir who is qualified to succeed to the property. The property does not devolve on the government. So here option C is the correct answer. Let's move to question number 20. What is codicil? It is a schedule to any kind of will. Option number 2. It must be created by the original creator of a will. It is an addendum of any kind to a will. Option number 4. It doesn't alter provisions of the will. We all know that codicil is an addendum to the will, and also it is created by the original creator of will. So the correct answer would be option number 2 and 3. That is option number C. Let's move to question number 21. President's rule under Article 356 of Constitution remains valid in the state for the maximum period of. This is also a direct question. So the correct answer is option number D, that is 3 years. Let's move to another. Okay, we just left this question. Let's move to question number 22. Which writ can be issued when appointment is contrary to the statutory provisions? Here, when appointment is contrary to the statutory provisions, that means he is holding the position without any authority. So here the correct writ would be the writ of quo warranto. By what authority you have been holding that position? Let's move to question number 23. Which schedule of the Constitution of India contains a list of recognized languages? This is also a direct question. The correct answer is 8th schedule. Let's move to question number 24. Under Indian Constitution, what is not included in freedom to manage religious affairs? A. To establish and maintain institutions for charitable and religious purposes. This is there. To own and acquire immovable property. Yes, this is also there. To manage its own affairs in matters of religion. Yes, this is also there. Which is not there. So option number D. That is to construct a religious place on government land. This is not there. So D is the correct answer. So let's move to question number 25. The decision of Union of India versus H.S. Dillon concerns the power of the Parliament to make law with respect to a matter not enumerated in concurrent list or state list. Option number B, the exclusive powers of state legislature to make law with respect to a matter enumerated in the state list. No. The scope of Parliament or legislature of state to make law in respect of a matter enumerated in concurrent list. No. The relation of fundamental rights and DPSPs. No. So here the correct answer would be the power of the Parliament to make law with respect to a matter not enumerated in concurrent list or state list. Let's move to question number 25. Period of limitation for any application is expiring on a holiday. The application should be made a day prior to holiday, may be made on the day when the court reopens. Option number C may be made within 30 days of reopening of the court. Option number D may be made on any day after the court reopens. So this is also a direct question. If you refer to section number 4 of Indian Limitation Act, you can find that the correct answer is option number B. That is may be made on the day when the court reopens. Let's move to question number 27. Section 5 of the Limitation Act applies to suits, appeals or applications, both A and B or none of this. We all know that section 5 does not apply to suits, so option A is eliminated, but it applies to appeals and applications. and this does not apply to suits as well as execution applications. So the correct answer is option number B. Let's move to question number 28. Section 5 of the Limitation Act does not apply to here, as I said in question number 27. The correct answer is suit. Which of the following proposition is incorrect? Where the disability continues up to the death of that person, his legal representative may institute the suit within the same period after the death as would otherwise have been allowed from the time so specified. And option number B, where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. Here it is a continuous running of time, that is section number 9. And in computing the period of limitation for any suit, the day from which such period is to be reckoned shall not be excluded. This is wrong because it shall be excluded. And number D, in computing the period of limitation for an application to set aside an award, the time requisite for obtaining a copy of award shall be excluded. Which of the following proposition is incorrect? So here option number, here it is asked which is incorrect. So the correct option is option number C. In computing the period of limitation for any suit, the day from which such period is to be reckoned shall be excluded. But here the word not is used. So option C is the correct answer. Okay, now let's move to question number 30. In which of the following circumstances the plaintiff shall not get the benefit as provided under section 14 of the Limitation Act? Mark the word shall not. Okay, it's not shall get, but it shall not. So option A is where another civil proceeding is disposed of after adjudication on merits by the competent court. Yes, because it is on merits. So here the plaintiff will not get the benefit of section 14 because section 14 deals with those proceedings which fails due to exclusion of time in those proceedings where there is defect of jurisdiction. But since there is adjudication on merits by a competent court, that means there is no defect. So option A is the correct answer. Other options are eliminated by default. Let's move to question number 31. The Bharatiya Nagrik Suraksha Sanhita 2023 received the assent of the President, that is CRPC, which will be known as Bharatiya Nagrik Suraksha Sanhita 2023. It received the assent of President on 25th December 2023. Let's move to the next slide. Question number 32. Offences against other laws except IPC, if punishable with imprisonment for 3 years and upward, but not more than 7 years. That means less than 7 years. Okay. Then it will be cognizable and non-cognizable. So it is offences against other laws except IPCs. This we can find in part 2 of per schedule. Okay. Part 2 of per schedule. Per schedule. Okay. There you can find that punishable with imprisonment for 3 years and upwards and less than 7 years. Less than 7 years. Okay. Less than 7. So there, if it is also a direct question, there you can find that it is cognizable and non-bailable. So let's see the options. It will be cognizable and non-cognizable. No. Non-cognizable and bailable, no. Cognizable and bailable, no. It is cognizable and non-bailable. Cognizable and non-bailable. So none of the options are correct. So this is there is a defect in question. So I think grace mark will be awarded for this question. Let's move to question number 33. Consider the following statements. A court has no power to release a woman on bail if the offence is punishable with death or imprisonment for life. No. This is not the case because court has power, court has its own discretion, so this option is wrong. Option number 2, an accused will not be released on bail by a court if he had been convicted previously on 2 or more occasions of a cognizable offence punishable with imprisonment for 3 years or more. Yes. And number 3, necessity for identification by witnesses during investigation shall not be sufficient ground for rejection of bail. This is also correct. So the correct answer would be option number 2 and 3. That is option number C. Let's move to question number 34. The magistrate's power to order imprisonment in default under section 30. Imprisonment in default under section 30 is cannot be in excess of the magistrate's power to order sentence under section 29, yes. And option number B, cannot exceed 1/4 of the period of imprisonment which the magistrate is competent to sentence, yes. So the correct answer is option number C, both A and B. Let's move to question number 35. Under section 428, that is set off, the period of detention undergone by a convict cannot be set off during investigation of the case, trial of the case, inquiry of the case, or any other case. So in these three cases, it can be set off. So the correct answer would be option number D, that is any other case. In this case, there cannot be any set off. Let's move to question number 36. A takes a loan of rupees 5,000 from B. A takes a loan of rupees 5,000 from B. Okay. So A is the debtor and B is the creditor. And mortgages his house as security. He mortgages his house as security. It was also mentioned that if he could not pay the amount within 5 years, if A could not pay the amount within 5 years, then B will have a right to sell the house and recover his amount. Then B can sell the house. Okay. Then B can sell the house and recover the amount. If the money could not be recovered from sale of house, then A will be personally liable. Here A will be personally liable. A will be personally liable when the money cannot be recovered by the sale of the house. So if you apply all the ingredients mentioned under section 58, there we can see that here, since A is personally liable, A has also mortgaged his property to B, and there is B can sell the property. So all the ingredients of simple mortgage is fulfilled here. It is it cannot be usufructuary mortgage, it cannot be English mortgage because there is no retransfer of property. It also cannot be mortgage by conditional sale because there is no ostensible sale. So the correct option is answer number D, option number D, that is simple mortgage. Let's move to another slide. Let's move to question number 37. The mortgagee's right to redeem the mortgage property accrues. Option number A, at any time after the mortgage. Option number B, at any time after the mortgage money has become due. Option number C, at any time when the mortgagor wants. Or option number D, at any time mortgagee demands the money. So here the correct answer is, it is also a direct question, nothing to overthink it. The correct answer is option number B. Let's go to question number 38. The mortgagee has a right to sue for the mortgage money in the following cases. When can the mortgagee sue for mortgage money? Option number A, section 68(1) clause C, where the mortgage is deprived of the whole or part of a security by or in consequence of the wrongful act or default of the mortgagor, yes. Option number B, section 68(1)(d), where the mortgagee being entitled to possession of the mortgage property, the mortgagor fails to deliver the same to him or to secure the possession thereof to him without disturbance by the mortgagor or any person claiming under a title superior to that of the mortgagor. Yes, so if you read section 68, you can find out that both the options are correct. Let's move to question number 38. Match list 1 with list 2 and select the correct answer using the codes given below the list. Doctrine of subrogation, we all know it is under section 92. Okay. Doctrine of consideration, doctrine of accumulation under section 17. Doctrine of list pendants under section 52, doctrine of consideration under section 61. So the correct option would be for A it's 4, for A it's 4, for B it's 3, for B it's 3, for C it's 1. So the correct option is D, A4, and for B it's 2. Yeah. Now let's move to question number 40. It says that A owes money to B, A owes money to B, who transfers the debt to C. B now transfers the debt to C. A is the debtor, B is the creditor, and he now transfers it to C. Then B then demands the debt from A. B now then demands the debt from A, who, not having received notice of the transfer as prescribed in section 131 of TPF, pays B. Since B demands, so A pays to B without having any notice that B has transferred the same to C. So here the payment is, whether the payment by A to B is voidable, valid and C can sue A for debt and C can sue A for debt. Valid and C cannot sue A for the debt. Here, since A did not have any notice that B has transferred the debt to C, so the transfer is so the payment by A to B is valid and C cannot sue A for the debt. So the correct answer is option number D. Well, let's move to the next question. Let's move to question number 41. As per the Indian Evidence Act, how old should the electronic record be in order to attract section 98? So this is also a direct question. The correct answer is option number A, 5 years. Let's move to question number 42. According to the Indian Evidence Act, which one among the following statement is not correct? Is not correct. When it is shown that a person was alive within 30 years, the burden of proving that he is dead is on the person who affirms it. Yes, this is from section 107 of Indian Evidence Act. And let's move to option number B. When it is shown that a person was not heard of for 7 years by those who would naturally have heard of him if he had been alive, the burden of proving that he is alive is on the person who affirms it. This is also from section 108 of Indian Evidence Act. When it is shown that a person is in possession of anything, the burden of proving that he is not the owner is on the person who affirms it. He is not the owner. Yes. Then option number D. When it is shown that one person stands to the other in a position of active confidence, the burden of proving the good faith of a transaction between them is on the party that reposed confidence in the other. This is a wrong option because it is on the person on whom the confidence is reposed. So here, since it is given not correct, so option number D is the correct answer. Let's move to question number 43. What does section 3 of the Indian Evidence Act deal with? Relevancy of facts, facts which need not be proved, facts in issue, or none of the above. We all know that section 3 of Indian Evidence Act deals with interpretation clause. So it deals with fact in issue, facts which need not be proved, and relevancy of facts. So here I think that there is a defect in the question because section 3 deals with interpretation clause. So there is a default defect in question. So I think grace mark will be awarded in this question. Let's move to question number 44. Under which section of the Indian Evidence Act can a witness be cross-examined on previous statements made by them in writing or reduced into writing? This is also a direct question. So the correct answer is section number 145. Let's move to question number 45. What is the rule regarding the admissibility of evidence of character in civil cases under the Indian Evidence Act? It is with respect to civil cases. We all know that section 52 to 55 of Indian Evidence Act deals with character evidence. So here 52 and 55 both deals with character with respect to civil cases. Under 52 we all know that it is irrelevant, character is irrelevant. However, under section 55 character for awarding damages is admissible in cases of character is admissible, character evidence is admissible. So here the options are character evidence is always admissible, no. Character evidence is never admissible, no. Character evidence is admissible in certain circumstances, yes. So option C is the correct answer. Let's move to the other question. Okay, question number 46. Continuing guarantee has been defined under, this is also a section based question. The correct answer is option number B, section 129 of Indian Contract Act. Question number 47. Who said that an offer need not be made to an uncertain person but no contract can arise until it has been accepted by an uncertain person? Again, who said that an offer need not be made to a certain person but no contract can arise until it has been accepted by a certain person? Lord Atkin, Lord Goddard, Shastri and Peafoot, or Anson? Here the correct answer is Lord Anson. Now let's move to question number 48. Quasi-contract emerged from assumption, indebitatus assumption, non-feasance, or misfeasance. So we all know that under Indian Contract Act, quasi-contract are dealt with under section 68 to 72. So here the question is quasi-contract emerged from assumption. So assumption is the right to claim damages for a breach of contract, no. Indebitatus assumption, yes. Non-faces misfaces? No. Let's move to question number 49. Which of the following is not a quasi-contract? You all know that section 68 to 72 of Indian Contract Act deals with quasi-contract. So here, obligation of person enjoying benefit of non-gratuitous act? No. Responsibility of not a quasi-contract. It is asking about not a quasi-contract. Obligation of person enjoying benefit of non-gratuitous act? It is a quasi-contract. Responsibility of finder good? Yes, it is a quasi-contract. Quantum merit? Yes, it is also a quasi-contract. Which is not? So novation is not a quasi-contract because novation is the substitution of a contract. Let's move to question number 50. X contracted with a tent house for erecting a shamiana for performing the marriage of his daughter. On the day of marriage, a curfew was clamped in the area, preventing the celebration of the marriage. The shamiana owner claims the charges agreed to be paid by X. In the light of the above, which one of the following is correct? Here we can see that there was a contract to install a shamiana for erecting a shamiana. However, due to some unforeseen circumstances, there was a curfew due to which the celebration was cancelled. Also, the curfew was not within his control. So, let's see which option falls to be the correct one. Option number A, X has to pay the contracted charges. X need not pay the agreed charges but only reasonable charges. Option number C, X can require the state to bear the claim for damages. Option number D, X need not pay anything as the celebration of the marriage was impossible on account of the curfew. So, the correct answer is option number D. This is based on section number 56 of Indian Contract Act, that is doctrine of frustration of contract. Let's move to another question. Question number 51. In which of the following case Supreme Court ruled that a suit seeking merely declaration to title of ownership about a property without seeking possession when the plaintiff is not in possession of the property is not maintainable? Union of India versus Ibrahim, Rukmabal versus Lala Lakshmi Narayan, Mayavanti versus Kaushalya Devi, or Ramzan versus Hussaini. So the correct answer is option number A, Union of India versus Ibrahim. Let's move to question number 52. In which of the following cases injunction cannot be granted? If it cannot be granted, okay. So it is dealt with under section 41 of SRA. Let's see, if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of relevant facility related thereto or services being the subject matter of such project, yes. When the plaintiff has personal interest in the matter, no. To prevent the breach of a contract, the performance of which would not be specifically enforced, yes. In such a case, injunction cannot be granted. To restrain any person from instituting or prosecuting any proceeding in a civil matter, no. Injunction cannot be granted in case of preventing him to institute a criminal matter but not in a civil matter. So the correct answer would be second and fourth. Oh, here what it is, cannot be granted. So cannot be granted is there. So since cannot be granted is there, so option 1 and option 3 will be the correct answer. That is option number C. Let's move to question number 53. Doctrine of lis pendens embodied in section 52, Transfer of Property Act, invalidate the transfer of immovable property during pending of suit, or it only enacts that the purchaser pendente lite suit is bound by the result of the litigation, it bars the transfer of property during pending of the suit, it protects the right of collusive transferee. So the most appropriate option would be option number B, that is it only enacts that the purchaser pendente lite suit is bound by the result of the litigation. Question number 54. A makes a gift of a land to B. A makes a gift of a land to B. Okay. C sues A for possession of the land. C sues A for the possession of the land. While the suit is pending, B transfers the land to D. While the suit is pending, B transfers the land to C. Okay. B transfers the land to D. A dies and C obtain a decree of possession against B as legal representative of A. Is D's title affected by the rule of lis pendens so as to be subject of C's decree? So here we need to see that the elements of section 52 are fulfilled or not. So one of the important criteria of section 52 is that during the pendency of suit, the property should not be transferred. But in this case, we can see that before C has instituted a suit, B has already transferred the property to D. Hence, the doctrine of least pendants won't apply in this case. Let's see what are the options. Option number A, yes, because transfer is without consideration, no. Option number B, no, because B was not a party to the suit at the time of transfer by B to D, yes, because the transfer took place before the institution of suit by C. And rest options, B is not legal representative of A for C's decree, no, this is not appropriate. After gift made to B, C cannot sue A for possession of the land, no. So the appropriate option would be option number B. Let's move to question number 55. Let's move to question number 55. Match list 1 with list 2 and select the correct answer using the codes given below the list. Sale, we all know. Section number 54, marshalling, it's section 81, gift, section 122, contingent interest, section 21. So the correct answer would be A3, B is 4, A3, B4, C is 2, gift is 2, contingent interest is 1. So the correct answer would be option number B. And question number 56, which statements cover the definition of domestic violence under the Protection of Women from Domestic Violence Act 2005? Any physical, emotional or economic harm inflicted by a family member, any act of violence committed against a woman in her home, any form of abuse that occurs within a domestic setting. We all know that section 3 of DV Act defines domestic violence. So here all the options are correct. So the correct answer would be option number C. Let's move to question number 57. Which of the following is not a form of domestic violence recognized under the Protection of Women from Domestic Violence Act 2005? Not recognized. Not a form. Mark the word not. So here physical abuse is there, verbal abuse is there. Both are true, yes. But here since there is not, so the correct answer is none is true. This is the correct answer. Let's move to question number 58. Section 22 of Protection of Women from Domestic Violence Act provides for protection order, residence order, custody order, compensation order. Residence order is dealt with under section protection under section 18, residence order under section 19. Monetary relief is not there, it is dealt with under section 20, and 21 deals with custody order, 22 deals with compensation order. So here the correct answer is option number D. Now let's move to question number 59. What is the punishment provided under section 31 of the Protection of Women of Domestic Violence Act 2005? It is the breach of protection order by the respondent. So here the punishment is 1 year imprisonment or fine, or fine of 2000 rupees or 20,000 rupees, or both. Now let's move to question number 60. Statement number 1. The PWDV Act 2005 provides for the establishment of protection officers to assist victims of domestic violence. Yes. The PWDV Act 2005 provides for rehabilitation of children of victims of domestic violence. It is partly true because under custody order there is a provision that the magistrate can order for the safe custody of children of the aggrieved women who are suffering. So here both are true. Since there is an option both are true, so option C would be correct. Let's now move to question number 61. Through 42nd constitutional amendment, which is also known as mini constitution, which of the following expressions were added to the preamble? Sovereign, socialist, secular or integrity. This also we all know the word socialist, secular and integrity, B, C, D. So option number B is correct. Let's move to question number 62. The Constitution of Election Commission is provided in the Constitution under Article 324. This is also a direct question. Let's move to question number 63. Which of the following judges of the Supreme Court is famously known as the Green Judge? Justice B.R. Krishna Iyer, Justice P.N. Bhagwati, Justice Kuldeep Singh or Justice B.N. Kirpal. So here the correct answer is Justice Kuldeep Singh. Let's move to question number 64. Can fundamental rights under Indian Constitution be waived by a person? Can fundamental rights be waived by a person? Yes, by every person. Yes, but only by a certain group of person. Only right conferring a benefit of the individual can be waived. Fundamental rights cannot be waived. So here the correct answer would be fundamental rights cannot be waived. Now let's move to question number 65. Alright. Question number 65. Sixth schedule of the Indian Constitution contains provisions with regard to administration of tribal areas of some states. Which of the following state is not included in it? Is it Meghalaya, is it Mizoram, is it Tripura, or is it Manipur? This is also a direct question. So the correct answer is option number D, that is Manipur. Let's move to question number 66. X and Y jointly take a loan from Z. X and Y jointly take a loan from Z. They took a loan from Z, okay, with promise to repay the loan amount with interest within 2 years. So they took a joint loan and promised to repay the loan within 2 years. Soon after taking the loan, X is declared as insolvent. Here X is declared as insolvent, okay, and remains insolvent till the date of repayment of loan. Y also fails to repay the loan. Y also failed. X on account of his status as insolvent enjoys immunity from legal proceedings. In these circumstances, Z can in law institute a suit for recovery of only 50% of the outstanding from Y, since both of them had jointly took a loan, or Z is entitled in law to sue Y alone for recovery of the entire outstanding amount. Is Y alone responsible to pay the entire amount? And option number C, Z is not entitled to sue Y also for recovery of loan amount till the order of insolvency of X ceases to operate, or Z is entitled in law to sue Y for 50% of the principal amount due and the entire interest outstanding. So here the correct answer would be Z is entitled in law to sue Y alone for recovery of the entire outstanding amount, since X enjoys the immunity of insolvency. Let's move to question number 67. This is from contract. Where two parties have made a contract, which one of them has broken, the damages which the other party ought to receive in respect of such breach should be such as may be fairly and reasonably be considered either arising naturally or reasonably be supposed to have been in contemplation of both the parties at the time of entering the contract. This statement was laid down in the case of Frost vs. Knight, Hadley vs. Baxendale, Dunlop Pneumatic Tyre Limited vs. New Garage and Motor Co Limited, or General vs. Barker. So here the correct answer is option number B, Hadley vs. Baxendale. Let's move to question number 68. Section 73 of the Indian Contract Act is based on the law of, this we all know, Hadley vs. Baxendale, because it deals with, section 73 deals with damages, and so Hadley vs. Baxendale deals with remoteness of damages. Let's move to question number 69. Let's move to the another slide. Right. Question number 69. For the purposes of the Specific Relief Act 1963, the word settlement means the word settlement has been dealt under section 2A of Specific Relief Act. So here let's see the options. Option number A, an instrument whereby the destination or devolution of successive interest in movable property is disposed of, no. Option number B, an instrument including codicil or will whereby the destination or devolution of successive interest in immovable property is disposed of or is agreed to be disposed of, no. Option number C, an instrument including codicil or will whereby the devolution of successive interest in movable or immovable property is disposed of, no. Option number D, an instrument including codicil or will whereby the destination or devolution of successive interest in movable or immovable property is disposed of or is agreed to be disposed of. So the correct answer is D. However, here the word including won't be there. So here there is a defect in the question. Maybe OPSC may consider the same. Let's move to question number 70. The Specific Relief Act 1963 is the product of, this is also a direct question, it is the product of 9th report of the Law Commission of India on SRA 1958. Question number 71. Which section of the Indian Evidence Act deals with the relevancy of statements made in the course of business? So course of business we can find in under two sections in Indian Evidence Act, that is section number 16 and section number 32 clause 2. So here the correct answer would be A, section number 32, not 33, 34, 35. So here the answer is option number A. Let's move to the another question. Question number 72. Which of the following document is not a public document? Judgment of a court, police charge sheet, mercantile contract, or will? Here, judgment is not a is not a public. It is a public document. Police charge sheet is a public document. Mercantile contract is a contract, but it is accessible to others also. So the most appropriate answer would be will. So will is the correct answer. It is not a public document. It is a private document made by a private person. Let's move to question number 73. Section 92 of the Indian Evidence Act is applicable to disputes between the parties to the suit only, to strangers where the document is in question, a party to the instrument and the stranger, or all of the above. So section 92 deals with the exclusion of oral evidence in case there is a document available. So the correct answer would be option number A, the parties to the instrument only. Let's move to question number 74. Relevancy and admissibility under Indian Evidence Act are synonymous, coextensive, neither synonymous nor extensive. Here the word co is missing. Or option number D, none of the above. So here the correct answer would be neither synonymous nor coextensive, because relevancy and admissibility are two different concepts. Some facts may be relevant but they may not be admissible. For example, privilege communication between husband and wife, that is relevant but it is not admissible as per Indian Evidence Act. Let's move to question number 75. The Indian Evidence Act was drafted by, this is a very easy question, Sir James Fitz Stephen. Let's move to question number 76. Giving or fabricating false evidence with intent to procure conviction of capital offence is provided under, this is section 94, direct question. Question 77. What punishment is provided under section 298 of IPC for giving or fabricating false evidence with intent to procure conviction of capital offence? This is related to question number 76. Here the correct answer is section 194. Here the section given is 298. So there is a defect in the question. So I think OPSC will consider the same. Let's move to the next question. Question number 78. A finds a gold ring on the road, knowing it to be the property of Z. He having unknowingly lost it there, A picks up the ring and pledges it with a money lender to raise a loan. A has committed dishonest misappropriation of property, criminal breach of trust, theft, or no offence. So let's see. A finds a gold ring on the road, knowing it to be the property of Z. So A knows that it is the ring of Z. Z unknowingly lost it there. So A picks up the ring and pledges it with the money lender to raise a loan. So here it is clear that A used Z's ring for his own profit, without his consent, without his knowledge. Also, since A found the ring in the road, so he did not took it from Z's possession. So it is neither did Z handed over the ring to A. So here these two options are eliminated. The only option available is dishonest misappropriation of property. So option number A is the correct answer. Let's move to question number 79. A is carried off by the tiger. Z fires at the tiger in good faith, intending to rescue A. Knowing it to be likely that the shot might kill A, the shot fired by Z gives A a mortal wound. Z has committed. Here it is a direct question from the illustration. So here it would be no offence because good faith is there to rescue A. Let's move to section number 80. A police officer tortures Z in order to induce Z to confess that he has committed a crime. Here A is guilty of offence of, so this is also an illustration question. If you refer section 330 of IPC, you can find that this is related to voluntarily causing hurt in order to extort confession. So here the correct answer would be option number C. Move to question number 81. An order or decree passed in a suit presented under section 6 of the Specific Relief Act is option number A, appealable, option number B, reviewable, option number C, neither appealable nor reviewable, or option number D, appealable and reviewable both. So this is also from section 6 subsection 3. That is 6 subsection 3, which clearly indicates that neither appeal nor review shall lie from any order or decree passed under section 6, but revision lies. Hence the correct option would be option number C. defendant in a suit for recovery or possession of immovable property can take the plea of lawful title, and in the alternative the plea of adverse possession? No. Cannot take the plea of lawful title, and in the alternative the plea of adverse possession. As the two are antithetical to each other? Yes, because these two things are antithetical to each other. Option number C, can take a plea of lawful title and in the alternative the plea of adverse possession and succeed on both? No. How can one succeed on both the things? Option number D, can take a plea of lawful title and in the alternative the plea of adverse possession and succeed on either. This is also not possible. So the correct answer is option number B, cannot take the plea of lawful title and in the alternative the plea of adverse possession, as two are antithetical to each other. Let's move to next question. Question number 83. If any person is dispossessed of immovable property without his consent, otherwise than in due course of law, he may, by a suit, recover possession thereof, notwithstanding any other title that may be set up in such suit within a period of. This is also a direct question from section 6 of SRA. So the correct answer would be 6 months from the date of dispossession. Let's move to question number 84. Which of the following proposition is correct? Where a party to the contract has not obtained substituted performance of contract in accordance with the provisions of section 20 of the SRA, option number B, a contract the performance of which involves the performance of a continuous duty which the court cannot supervise. Yes, continuous duty court cannot supervise. This is as per section 14 of SRA. And option number C, a contract which is in its nature not determinable. No, it is determinable, or all of the above. So the correct answer here would be option number B. This is regarding section number 14 of SRA. Now let's move to question number 85. Mr. A makes an allegation that Mr. B assaulted him and physically injured him. Mr. B states that the allegation is mischievous and false. He seeks to file a suit to restrain Mr. A from instituting or prosecuting any proceedings in a criminal matter. In view of section 41 of the SRA, which one of the following is true? Option number A, the court can restrain Mr. A from instituting or prosecuting any proceeding in a criminal matter. Option number B, the court can pass a restraint order provided it is proved that Mr. A is making a false allegation. Option number C, the court can pass a restraint order in favor of Mr. B provided it deposits appropriate security in court. Or option number D, no such injunction can be granted. As we all know that section 41 of SRA deals with where injunction cannot be granted. So here the correct option would be D, no such injunction can be granted, because injunction cannot be granted to prevent somebody from instituting any proceeding, any criminal proceeding. So D is the correct answer here. Let's move to question number 86. In coparcenary property, each coparcenor can acquire interest by partition, birth, attaining majority, or all of the above. As we know that after 2005 amendment in section 6 of Hindu Succession Act, even female are now coparcenors by birth. So here the correct option would be birth. Let's move to the next question. Let's now move to question number 87. Under the Hindu Succession Act 1956, daughter, son and father of a male Hindu, suppose H is a male Hindu, daughter, son and father, his father and his daughter's son, that means his grandson, of male Hindu are legal heirs, and they are placed as the following. Both are placed as class 1 heir of the schedule. Father is placed in class 1 and daughter's son is placed in class 2 of the schedule. Daughter's son is placed as class 1 and father as class 2 heir of the schedule. Both are class 2 heirs of the schedule. Here also we need to refer to the class 1 and class 2 heir mentioned in the schedule of Hindu Succession Act. So accordingly, father is always a class 2 heir. So father is class 2 heir, but under the Hindu Succession Act, there is no mention about daughter's son. So there is a fault in the question. So there is a possibility that OPSC will consider the same and the grace mark will be awarded for the same. Let's move to question number. However, if you refer to single or some other publications, there the answer given is option number C. Let's now move to question number 88. The convert's descendants under the Hindu Succession Act 1956 will be option number A, qualified to inherit the property, option number B, partially qualified to inherit the property, option number C, partially qualified and partially disqualified, no, option number D, disqualified to inherit the property. Yes, this is a direct question. This is from section 26 of Hindu Succession Act. Now let's move to question number 89. In the case of Prakash versus Pulvati, the court dealt with section 5 of Hindu Succession Amendment Act. Option number B, interpretation of section 6 of Hindu Succession Act as amended by Hindu Succession Amendment Act 2005, or option number C, that is question of retrospective application of Hindu Succession Amendment Act 2005, or option number D, none of the above. So here the correct answer would be option number C, question of retrospective application of Hindu Succession Amendment Act 2005. Now let's move to question number 90. The system of a joint family with its incident of succession by survivorship is a peculiarity of the Hindu law. The beneficial interest of each co-partner in Mitakshara law is liable to fluctuations, increasing by the death of another co-partner and decreasing by the birth of a new co-partner. This was held in the case of G. Rajendra versus Srimati G. Nalini, no. Vinita Sharma versus Rakesh Sharma, yes. And the Prakash versus Pulvati, no. None of the above, no. So the correct answer is Vinita Sharma versus Rakesh Sharma. Let's now move to question number 91. Okay, mark the incorrect statement. This is from CPC section 11, res judicata. Res judicata stops the parties from proving the previous decision to be incorrect. Yes. Res judicata corresponds to that part of the doctrine of estoppel which is known in English law as estoppel by record. Yes. Res judicata is similar to estoppel. No, it is not similar to estoppel. Here it is given that which statement is incorrect. So the correct answer would be option number C. Let's have a look on option number D. Res judicata ousts the jurisdiction of the court to try the case, while estoppel shuts the it would be shuts, it's not shouts. Shuts the mouth of a party, being a rule of evidence. This is also correct. So the correct answer here would be option number C. Let's now move to question number 92. The place of suing in a suit for restitution of conjugal rights, that is which is given under section 144. Restitution of conjugal rights is the place where the husband resides, where the wife resides. If the wife has never lived at the husband place, the suit must be brought in the court of the place where the wife resides, or all of the above. So here it is all of the above. You can file the suit anywhere where the husband resides, where the wife resides, or where if wife has never lived at the husband place, the suit must be brought in the court of the place where the wife resides now. Now let's move to question number 93. A party may approach the court for an amendment of his opponent's pleading, also known as compulsory amendment. It is provided for under. So if you have read the orders properly, you can easily identify here all the orders are same. So you need to really mug up the rules. So normally the amendment of pleading is provided under Rule 17. So here the correct answer would be option number C, Order 6, Rule 17. Now let's start with question number 94. If a party who has obtained an order for leave to amend pleading does not amend the same within how many days, he shall not be permitted to do so without leave of the court. Options are 15 days, 14 days, 20 days or 30 days. So here it corresponds to Order 6, Rule 18. So here the correct answer is option number B, that is 14 days. Now let's move to question number 95. Abatement of proceedings is provided for under Order 22, that is which deals with death, marriage and insolvency of parties, or Order number 23 which deals with withdrawal and adjustment of suits, Order number 24 payment into court, or Order number 25 that is security for costs. Here abatement of proceedings, it is very clear that it corresponds to Order number 22. We can find this provision under Order 22, that is death, marriage and insolvency of party, wherein the suit can abate. Now let's move to question number 96. Okay, wrongful confinement in secret is dealt with under, it is also a direct section based question. The correct answer is option number C, that is section 346 of IPC. Question number 97. A is tried for voluntarily causing grievous hurt and convicted. The victim subsequently dies. The state wants to try A for the offence of culpable homicide amounting to murder under IPC, which one among the following is the correct legal position? Option number A cannot be tried for the second time as per section 300 of CRPC, that is octroi acquit and octroi convict. Or option number B, A was already convicted and punished, hence cannot be tried second time under the law. Or option number C, A can be tried for the second time for culpable homicide amounting to murder. Or option number D, A can be tried once again for the same offence that causes death. So here this question corresponds to illustration B of section 300. You can find it in the CRPC barrack. So the correct answer here would be option number C, that is A can be tried for the second time for culpable homicide amounting to murder, because here grievous hurt resulted in the death of the victim. Now let's move to question number 98. Extortion by threat of accusation of an offence punishable with death, life imprisonment or imprisonment for 10 years is dealt under. This is also a direct question. So it is from section 388 of IPC, that is option number D. Let's see question number 99. A holds B down and fraudulently takes B's cell phone from B's trouser without his consent. Here there is no consent of B. A holds B down and fraudulently takes B's cell phone from B's trouser without his consent. Under IPC, A commits the offence of option A robbery, option B extortion, option C dacoity. Dacoity won't be here because dacoity involves more than 5%, and criminal misappropriation. So there is no criminal misappropriation also because B has not handed A his phone. So here there is a we need to find out whether it's robbery or extortion. It is not also extortion, because in extortion the victim has to deliver it to the perpetrator, but here this is not the case. So the correct answer would be robbery, option number A. Let's move to question number 100, our last question. A obtained a decree against B for a sum not due. It may be an offence under IPC if A has done so. Now here we need to find out what is the correct mens rea. So is it negligently, is it fraudulently, is it in good faith? Good faith won't be a problem, or all of the above. All of the above is also nullified. So here we need to find out whether the mens rea was negligently or fraudulently. So here the appropriate mens rea would be fraudulently. That's it. We have completed set C of OJS 2023 examination. Thank you.